I'm going to do a little bit about civil litigation. Are you all happy so far? You all with it? No questions? How does civil litigation work? First of all, you have to argue that you, as an individual, suffered loss. Loss can be anything. It can be physical, it can be emotional, it can be loss of opportunity. For most people who are MSDs, the loss tends to be, I can't work, or it might be, I can't play with the kids, I can't play football, I can't do whatever I used to do. Three things then matter. The first of which is, was the person who essentially argues that they suffered loss, were they owed a duty of care? Now, in civil law, the strongest duty of care is that of the employer to the employee. Now, everybody, almost without exception, owes everybody else a duty of care. Right now, I owe you a duty of care, you owe me a duty of care, Cardinus owes us a duty of care, you owe Cardinus a duty of care. But typically, the strongest duty of care is that of the employer to the employee. And what you'll see is most civil claims are an employee suing an employer. Now, I'll be honest with you, an employee could choose to sue their manager, or could choose to sue their manager's manager. You can pretty much choose to sue anybody in that line, but typically your manager's not rich enough to be worth suing. So you pick the organisation because that has to have insurance and it has to have a big pot of money. That means you can go for it. These three things, though, if you can't prove them, you have no case. So typically the employer owes a duty of care to the employee, and then the claimant has to demonstrate that that duty of care was breached. And this is where we go back to criminal law. The easiest way to demonstrate the duty of care was breached is that the employer failed in an absolute duty. So, in terms of what does it look like, have you got a risk assessment? And if the answer is no, then it's highly likely that you are in breach. If the answer is yes, was the risk assessment any good? And what that will mean is if the risk assessment says the person needs to be trained, were they trained? And the absence of records is proof that they weren't. So you can't go and say, yes, we definitely trained them, we don't know where the training records are. Yes, we definitely informed them. Yes, we definitely did a risk assessment. Because following a civil case which was basically against BT, we now have a line in the sand that says, if there is no records, it didn't exist. The onus is on the employer to demonstrate that they did stuff. And this goes back to part of the Health and Safety at Work Act, what's called Section 40, which is the reversal of the burden of proof around what was reasonably practicable. And basically the organisations have to show that they did stuff. It's not up for the claimant to show that the organisation should have done stuff. If there is a breach, this link here is called causation. Did the breach lead directly to the loss event? Now, it's fair to say that a lot of courts now, particularly the lower courts, will not hear arguments of causation. They go, the person is injured, you breached it, you're to blame. And this has led to a lot of complaints from the great and the good. Strictly speaking, you have to show causation. Most courts, though, will go, if you've got sufficient evidence of a breach, we'll accept causation. And it works. They use a test which is called the Sherlock Holmes test. So a really good risk assessment would identify risk and reduce it. So if you need to do a risk assessment, that implies that there might be risk. Okay? So if you didn't do a risk assessment, and there's no risk, or if the person's got injured, that's clearly causal. Had you done the risk assessment, you would have identified that risk and eliminated it, wouldn't you? And that's how it works. Now you've got to say it's a very weak argument, but the idea is that's how the courts work. And it's when you eliminate the obvious, whatever you've got left is when you eliminate everything, whatever you've got left, no matter how bizarre, is the solution. And we saw it in a case of 5 people against a bank, where basically they worked in a friendly exchange, where the courts heard that they'd all been injured, and the judge directed that actually this is how his logic was. The bank accepted that these individuals had been hurt. the bank accepted that they weren't malingerers, they weren't making it up. So the judge said there's only two explanations. Either they were hurt by work, or they were hurt by not work. Okay, follow that so far? As the bank presented no evidence that they were hurt by not work, he had to assume that they were hurt by work, and therefore they won their case. Now, what that means to you is the absence of records is not a good place to be. And if you do one thing as a result of this talk, go back and audit yourself and find out whether you've got the right records. Because if you do have a civil claim, the absence of records can be very telling indeed. And look, in terms of litigation, it's all about compensation, it's all about claiming, loss. It's all based upon this concept of harm, and you have the three components, which is pain and suffering. For MSDs tends to be very small. Loss of future earnings varies from very small to ginormous, and medical expenses depends upon the condition. That's the biggie. That's where a lot of what's called quanta arguments are heard. How much loss of earnings has this person got? Because essentially, if you have somebody with a bad back, if the courts believe that the person will never work again, and they're a 40-year-old male, basically their compensation is commensurate with that. So when you read about claims in the paper, when you read about claims of settlements of £500,000, what that will be is it will basically be the courts have decided this person will never work again, so that award is what they would do. Now, if the person starts to work again, you have to court and basically get some of that back, and sometimes it's held in a separate account, and the courts will monitor what happens. But it's big bucks. So rule 1, don't hurt people. Rule 2, if you do hurt them, at least document that you shouldn't have done. And rule 3, if you do hurt people and you have documented it, get in early. Because let me say again, those things will count in your favour in a civil claim. And then you get all of this. The couple of things that I put there that are basically worthwhile. The first two are basically doctors. This is meaningless. It's a meaningless diagnosis. If somebody comes back to you with that, you can't do anything about it. It just says they've got pain. It's a really good way of getting rid of a patient if you're a GP though. You put a really great you've got regional fibromyalgia. That just means you've got pain. You go to the doctor, I've got pain, the doctor writes in the prescription, yeah, you've got pain. You can't treat it, it doesn't say what caused it. This is important because basically when Nurse Commons sued Queen's Medical Centre, what she was able to argue was that her injury was cumulative. For the first time now we basically have a benchmark that says it's not just about, if you like, single episodes, because the whole feature of DSE and manual handling cases in the past have been on single episodes. We now have a notion of cumulative harm which says, do you know what, if you are exposed to a problem for long enough, it is perfectly plausible that you will become injured. Now, the problem then is if you've got a cumulative harm injury, how do you actually rehabilitate? And it seems to me that one of the challenges for a lot of organisations are they tend to not to do anything. They don't have a plan for this. These are interesting because they absolutely link to RSI and to MSDs and to the whole debate. What you will see in the very early cases, when it was called RSI, you saw essentially what I think were probably bullying and harassment claims, which were just settled as RSI claims. We also see stress on the MSD side as being quite a big predictor of whether somebody's going to go off with a musculoskeletal disorder. And this is a problem because the minute you do a stress audit, you establish the point at which you know you have a problem. So if you audit your organisation for stress, you then establish the date at which you knew you had problems. And if your stress audit comes back, say lots of people are complaining about aches and pains and are really ticked off with work, you can't later on argue that you didn't know you had problems. So if you're going to do stress audits, be very careful and do them properly. Seek some sort of expert advice. In terms of the stuff that you'll see in litigation, talked about causation. That's an important one. Foreseeability tends to be, the concept there is, was the injury reasonably foreseeable? And you sometimes get experts arguing about reasonableness around foreseeability. You need to have safe systems of work that are documented, and you need to have basically ways of showing that people can cope if things go wrong. Coping strategies tend to look like referral to occupational health, calling in experts, getting people into fast track physio, etc. It is basically a relatively complex area, and we see people don't get this. As I said, it is duty of care is owed to everybody. I think those two duties of care are the least likely to be contested. If you pay somebody, they work for you, you owe them a duty of care. In terms of causation, what's a problem for MSDs and stress is it's really hard to have a clear link between a particular situation and a particular injury, and so the courts do tend to fudge it. And my advice would be, if you go into bat on a civil claim and your only argument is causation, you will lose. And in terms of the sort of things that you have, what should you know? You should know stuff that is out there in the public domain. You should understand what similar organisations are doing. You should understand when you should know things. And then finally, what do people do? Actually, really unusually, the DSE regulations are the first and only regulations to date that actually require managers to manage. Really bizarrely, it's a real peculiarity of the DSE regulations. They actually require managers to manage, and there's a regulation contained therein that says, you know, managers need to know the work habits of the people that they're managing. But essentially, it's about knowing what's going on, and it's particularly about having risk assessments with clear links to risk controls. And this is the sort of stuff that people defend on. This is how you will lose a case. What do we mean by training? We've always done it. What about their Section 7 or Section 8 responsibilities? These, we'll fight it on medical grounds. That tends to be the causation one. Or we'll just try everything. We'll try and rubbish the claimant. We'll try and rubbish the expert. We'll try and rubbish the whole system. And it's fair to say that if you are relying upon these sort of defences, you will lose. The most robust defences tend to be, we have a risk assessment, we have a fast track for medical referral for occupational health, we've got the records, the person was trained, we've got the records, the person clearly knew that they should have flagged the problem, 5 other people have done that, they've had no disciplinary against them, they're still working with the organisation, we don't understand why they didn't say anything, it's a mystery to us. And incidentally, they basically are writing their PhD on a crappy laptop at home. That might have something to do with it as well. And at that point, you've got a defence.